everyone, and welcome to the third session of the day. My name is Hodan Omar, and I'm a policy analyst at the Center for Data Innovation. And I'm really excited to be moderating this session, Fueling AI with Data, Addressing the Privacy and Civil Rights Challenges. As many of you joining, I'm sure, are already aware, considerations of the privacy and civil rights challenges related to developing and using AI systems are having a public moment, with policymakers and practitioners newly and increasingly attuned to their import. But what exactly are the privacy and civil rights challenges? And more importantly, what are the most effective ways to address them so that we maximize the nation's overall social and economic welfare while minimizing harms? Thankfully, we have a really stellar panel today to discuss exactly that. And I'm going to do some quick introductions before we hear opening remarks from each of them. So we have Travis Hall, who is a telecommunications policy analyst at the US Department of Commerce's National Telecommunications and Information Administration. Dr. Sarah Jordan, who is a senior researcher in AI and ethics at the Future of Privacy Forum. Paul Lacasse, who is a senior vice president in global public policy at SIIA. Jordan Crenshaw, who is vice president at the US Chamber of Commerce's Technology Engagement Center. And Stephen Sanford, who is managing director in strategic planning and external liaison at the US Government Accountability Office. Big breath for a very distinguished panel. And as a quick reminder to everyone joining, this is a really interactive session and we encourage you to ask questions at any time. And with that, I'll hand over to Travis, who's going to start with his opening remarks. Travis, the floor is yours.
All right. Hi, everybody. And thank you so much for having me and hosting us here. And I particularly appreciate that we were able to hear earlier in the day from Deputy Secretary Graves on the importance of transatlantic data flows and interoperability. And on this topic, artificial intelligence is absolutely top of mind for the administration. It is a key emerging technology issue, both in terms of, as we noted probably a bit earlier, some international data flows, but also in terms of how we're thinking about things domestically. And just a little bit of background with that said on NTIA and who we are. We are a part of the Department of Commerce. We have a number of different hats. We manage federal spectrum. We are going to be responsible for putting out the broadband grants and have a lot of focus on accessibility and adoption of the internet. But we also serve as, by statute, the president's primary advisor on telecommunication and information policy issues. And that is where I sit, is in that policy advisor space. And we cover a range of topics, including emerging technologies, privacy, cybersecurity, and so, some national security issues as well. And AI touches on all of those. Now, before I get into some of the activities that we're doing, let me take a step back quickly and talk a little bit about some of the initiatives that are going on within the administration. At the highest level, the Office of Science and Technology and Policy is leading up the AI initiative. And this is a new initiative, but it builds on work that has been in place since, I would say since the Obama administration, in terms of some of the research strategy and some of the work that has been done through the Trump administration, and now is coming to fruition here in this initiative. One of the most important things that is to note about the AI initiative is that it is going to be driven in part in terms of its direction by a what's called a FACA. And a FACA is an advisory board of individuals with expertise from outside the government who come in and actually help to advise on direction. And to be just for notes, that nomination process is currently open for that. So if you know people who have the expertise and interest in that, we would love to hear from you. One of the other areas in terms of talking about direction that will be talked about a little bit more later by my fellow panelists is, of course, the National Security Council on AI's report. So I would say that those two initiatives are the two primary driving factors in terms of how the administration is approaching the topic of artificial intelligence. On a slightly lower level, within the department, NIST the National Institutes of Standards and Technology, is actively working on a risk framework, looking to address how companies should actually assess and then mitigate the risks that are being caused by artificial intelligence and other algorithmic decision making. And this is building on the work that they've done in both the privacy and the cybersecurity spaces. In terms of NTIA, we've been playing a role helping to support all of these initiatives. We also were very active in the international stage at the OECD in helping to draft the principles on artificial intelligence. And we are continuing on in that role right now. One of the primary areas of policy development that we do work on, apropos of this particular conference, is privacy. And so we are actively engaged on the questions of privacy and how emerging technologies do affect that, what types of policy responses are required, and whether or not we would be recommending any either executive actions or legislative changes or things like that. And those are ongoing policy conversations that are actively happening right now. And so with that, I'd be more than happy to pass it along to my fellow panelists, and I'm really looking forward to the conversation. Thank you so much.
Thank you, Travis. Sarah, over to you.
Yeah, thank you so much for having me this morning, Hothan, and thank you for the tee off there, Travis. That's actually a really interesting place for me to start in terms of what's coming down in terms of AI regulation, whether or not that's going to be regulatory action that's bubbling up from some of the agencies, from the externals, or from some of the states. There's so much interesting work right now being done in terms of, well, crafting regulation that's going to potentially help to guide AI, is going to help communities to navigate in terms of how they're going to interact with AI here in the future. And I think one of the things that's top of the mind for a lot of us, whether or not we're in the AI specific space, whether or not we're coding, whether or not we're trying to sell AI, or whether or not we're trying to help others to manage and navigate the privacy risks around AI, is, well, what about the regulation? What's coming down? Certainly, we saw such interesting things come out of the European Union in April. I think a lot of us are still paying careful attention to what's happening over on the other side of the Atlantic, but there's some interesting stuff going on here as well with our states. And I think one of the things we're particularly concerned about over in the AI side at Future Privacy Forum is, well, what should we be looking for in terms of privacy protective regulations for artificial intelligence? I think one of the first places to start is that there does need to be a regulatory framework for artificial intelligence, and there needs to be some sector-specific regulations for the AI and the machine learning that's used. I think there's a couple of ways in which we can parse some of that, though, right? A regulatory framework, something that's a big overarching set of principles and procedures, should be able to help us to contain some of the specific regulatory efforts. And that framework, as well as those specific efforts, should be both sensitive to the privacy risks as well as the concerns for data utility, because ultimately we want AI to work. We want it to provide the spectacular benefits that people say, while mitigating and managing some of the risks that could emerge as we use some of this data. So at present, what we're paying attention to is the action in the states, and looking, for example, the legislative experts in Massachusetts or New Jersey or Montana or Virginia or Colorado. There's so many interesting things going on right now. And one of the key things that we're tracking is, what about those impact assessments that people are talking about? You find this in a lot of the state bills, and in proposed even federal level legislation. What is an algorithmic impact assessment? What's it supposed to do? What are its components? I think those are really key, important questions for us to grapple with right now before we get captured in some cases by language that may have gone a little bit in advance of either the technology or the offices necessary to help to manage that. So for example, the impulse of an impact assessment is a great one, right? But we probably want to start to consider how it is that an impact assessment should work, right? What's going to be included in all of these impact assessments? Who's going to be doing the evaluation of those? Who's the target audience, right? how are we going to make sure that affected communities, whether or not that is a very broad base of consumers that use even things just basic as the internet and broadband services, which do definitely themselves rely on AI to help to keep, well, the internet on for all of us, but also in very narrow communities and industry-specific communities, to make sure that the impact assessments we craft, well, help them to build better AI within in the future. Also, how do we make sure that government agencies and private firms are able to answer the mail that's going to come from citizens and consumers about the impact of the impact assessment? How do we make sure that that instrument is something that is useful, is forward-looking, is protective of an AI-enabled future? After all, I mean, if we have some sort of impact assessment that isn't reaching the communities, whether or not that is industry or citizen groups or interest groups or advocacy groups, if they're not ultimately able to read it, if they're not able to access it, if they're not able to influence that impact, then what's the point? So before all of the states copy one another's definitions of AI impact assessment, we are seeing that trend emerge here. Maybe we should take a step back and learn from two key audiences here. So the researchers who have studied extensively the effect of environmental impact assessments. Let's see what we can learn from them. So for example, as Travis was saying, in terms of NIST's creation of a regulatory framework around risk for AI, well, how can we import some of the other risk language that has been done in terms of other community, society affecting things such as environmental impact? And let's talk to those other folks in the environmental justice side to make sure that we don't perpetuate things such as not listening to those people who feel the sting of adverse impact from either environmental change or development or technology. So listening to researchers and relevant stakeholders is something we absolutely must do when we're creating regulations and we're creating public policies. It's a great start. But ultimately, those regulations, they're going to have to balance privacy, they're going to have to balance ethics and data utility. And they're going to have to account for all of that in sectors where AI is used in ways that we grapple with every day and in ways in which we never see at all. So for example, things like the infrastructure, the AI that's used to power the infrastructure that we have, right? So general purpose AI regulation, it's probably not going to be anything more than a framework that helps us to organize those principles, those things that things like the National Institutes of Standards and Technology are working on in terms of principles and explainability principles and explicability and interpretability principles. It's going to have to, whatever we do is going to have to account for the differences in the sources and the types and the size of data that's needed for training, testing, validation, and then retesting and revalidating all of the AI that's built for us. Effective regulation, it's going to have to account for differences in data architecture and customer demands for those specific industries. And finally, actionable regulations, they're going to need inputs from people at the sharp end on AI. Not only those people who are affected by AI and use AI, but also those people that are building it. Starting from people with their hands on the keyboard, making sure that they're making decisions and are making this documentation that support those decisions. So that way we can have a clear view into the future of how we expect AI to work. Not to say that any of this is an easy task, right? Certainly this is going to be a multi-year, multi-agency task that's going to affect all of us sitting here talking to you on this screen today. And there's no one right way to do that. But at least beginning this conversation as we're doing today is one way to think forward about a more actionable regulatory future. Thanks, Hosen.
Thank you, Sarah. Paul, over to you.
Great. Thank you so much. It is a privilege to be here today, and especially to follow Sarah and Travis, whose comments I thought were just wonderful. And hopefully what I have to say here will pick up on some of the themes that they've already introduced us to. There's certainly growing attention today to the risks of artificial intelligence and the negative externalities that arise from the application of AI technologies and AI-enabled systems. Algorithmic bias is near the top of this list, and there are ways in which machines may render decisions on individuals that historically have been done by humans. So too is disinformation, a problem that existed without AI, but one that has become exponentially more problematic now, moving at the speed and scale of AI. And with respect to government conduct, the use of AI in certain domestic contexts may raise unique constitutional questions. There's also a vastly growing literature of best practices to address bias and some other concerns to promote what is referred to as trustworthy, ethical, or responsible AI. To pick up on what Travis said, there's a lot of excellent, thorough work being done on these issues right now in the US government. Before recently joining SIAA, I was with the National Security Commission on Artificial Intelligence, where I saw this up close. I'd like to particularly commend NIST, which is doing excellent work on bias and developing a risk management framework. There are 3 points I'd like to make today on the topic of regulating AI. First, in the United States, while we're seeing a handful of laws at the state level, as Jordan will address in more detail and Sarah just spoke to, Congress has yet to act. This is not for a want of proposals. The Algorithmic Accountability Act, for example, which was introduced a couple of years ago, would have provided a framework for addressing bias. What's likely, however, in the near term is that we're going to see regulation more by enforcement at the federal level, especially coming out of the FTC. And I'm not so sure that's a good thing. We want a robust public debate about the effects and uses of AI and whether safeguards are needed. And it would stand to reason that Congress could lead the way in creating that debate rather than reacting to administrative and court-made law. Second, I think we need to think creatively about how to supplement voluntary frameworks to create safeguards around AI. I'd argue that resources should be focused on addressing the key high-risk uses of AI and the most significant negative externalities. In other words, a contextualized use restriction model, one that is targeted. As Sarah spoke about, considering sector-specific regulations may be a productive way to go about looking at targeted safeguards. Not all impact assessments are alike, and we need to really focus in on what's necessary to achieve the concrete outcomes that we want to see. A comprehensive piece of AI legislation, such as the one that's being considered in Europe, in the United States may make it more difficult to generate productive uses of AI that help address societal challenges. The burden would be felt especially on small, medium-sized companies, and I have concern that it's not sufficiently adaptable as the technology advances. If there is any sort of compliance requirement for high-risk systems, we really do need a legislative framework that provides sufficient flexibility to adapt as the state of AI matures. The landscape today looks very different today than it was even just 2 years ago. And third, we need to think not only about private sector use of AI, but also government use. Most important are those government uses of AI that come against rights and liberties enshrined in the Constitution. There's not been enough concrete work to ensure that AI in the law enforcement, criminal justice, immigration, and public safety contexts meets the explainability, audit, documentation, testing, evaluation, verification, and other needs of responsible AI. I look forward to the remainder of this conversation and look forward to hearing your questions. Thank you very much.
Thanks, Paul. Jordan, over to you.
Thank you very much for having us today, and I really appreciate the opportunity to talk about this important issue. Artificial intelligence is going to be a game changer for society and the economy at large. In fact, McKinsey has estimated that it will have a $13 trillion impact worldwide by 2030. But one of the key things that we have to look at as we're regulating new technologies is the definitions of what we're actually regulating. Much like privacy, which is a concept that, in fact, in many ways we're still looking to define. Artificial intelligence itself is a technology that also is in need of precise definitions. Overall, there are certain types of terminology that are important in this debate. Obviously, we're dealing with algorithms, which are ways of solving problems in the digital world. And AI is an intelligence that's demonstrated by machines learning and problem solving as well. But there are different types of digital problem solving. There's machine learning, in which there's a use of algorithms to perform tasks without explicit instructions. And then there's deep learning, in fact, in which there are learning of machines based on data representations and not necessarily specific tasks. But we're still trying to nail down what those definitions are, even with these broad, vague concepts of what we think AI is. In fact, we've seen several proposals in legislation that currently work to define AI. For example, in the John McCain NDAA, one of the types of AI was defined as any artificial system that performs tasks under varying and unpredictable circumstances without significant human oversight, or that can learn from experience and improve performance when exposed to data sets. But then we see other definitions out there. We've seen definitions from Canada saying that information or an artificial intelligence is information technology that performs tasks that would ordinarily require biological brain power to accomplish, such as making sense of spoken language, learning behaviors, or solving problems. The European Union has its own definition in terms of AI and has actually redefined it recently. The International Organization for Standardization has defined AI to mean the capability of a functional unit to perform functions that are generally associated with human intelligence, such as reasoning and learning. But why does this matter? Why do definitions matter? They matter because they impact how to regulate and who is regulated. For example, we've seen in the Algorithmic Accountability Act a definition that is basically for automated decision systems, a computational process, including one derived from machine learning, statistics, or other data processing or artificial intelligence techniques that make a decision or facilitates a human decision-making that impacts consumers. That can get pretty broad. And we start to get concerns that if we have things like if-then statements, that could bring in a large number of entities and programs and technologies into the fold of what's legally considered artificial intelligence when they really don't belong there. For example, an Excel spreadsheet could potentially be viewed as artificial intelligence if we don't write the definition right in the laws that are regulating them. I give an example of a few years ago when the FCC defined an automatic dialer under the Telephone Consumer Protection Act as anything effectively that was not a rotary phone. We've recently seen the Supreme Court narrow that definition down, but definitions matter. I think it's important as well to if we haven't nailed down legally what that definition is of artificial intelligence, let's get a feel for at least some of the use cases of what AI is doing. AI can be used to help autonomous vehicles begin to help save lives with self-driving cars, for example. As we know, 97% of fatalities on the roadways are caused by human error. AI is being used in the medical context to identify spike proteins and to develop vaccines and treatments quicker. We're also seeing AI being used in the financial services context to ensure inclusion and to use new data sets and types of data to bring folks into the fold who were previously unserved by credit to give them an opportunity and a leg up as well. So we see several of the examples of what AI can do. We don't have a legal definition yet, but it's also important that we bring stakeholders together, much like NIST is doing, much like we're seeing over at OSDP and the rest of the Department of Commerce. But one of the things that we find important as the business community is also to get a consensus on these very important issues. We're actually bringing together at the U.S. Chamber of Commerce a bipartisan commission this fall with former members of Congress and stakeholders from across the spectrum to develop solutions to these very issues, such as what is AI? How do we regulate it in terms of privacy and bias? How do we get the workforce of the future prepared? And finally, how do we compete internationally? More to come on that, but I'm thrilled to be part of this conversation, and thank you very much for having me.
Thanks, Jordan. Last but not least, Stephen, the floor is yours.
Thank you, Hoden. Thank you, fellow panelists. It's a pleasure to be here today. I am from the U.S. Government Accountability Office, and for those of you who aren't familiar with our mission, we are an independent and nonpartisan agency in the legislative branch of the U.S. federal government. And our mission is to provide Congress with impartial analysis and oversight of government programs at the federal level. And as you might imagine, AI is an area of major concern and interest up on the Hill. And by consequence, in the work that GAO has been doing and that we expect we will do in the future. Back in 2017, we first put a marker down saying that we anticipated AI would be a major factor in with consequences in society and in government when we were developing our strategic plan for GAO to serve the Congress back in 2018. And indeed, in 2018, we did our first technology assessment at the request of Congress looking at artificial intelligence. We focused on high consequence activities around AI and the implications that could be understood about how AI might progress and the types of policy issues it would raise. And indeed, some of the things that Jordan just mentioned in terms of automated vehicles, healthcare, and financial services were areas that we've looked at, in addition to spaces such as the criminal justice system and cybersecurity, and also the financial system. So it's certainly something that we've already dedicated some work to in the past. This year marked a watershed for us in we issued the government's first ever framework on AI accountability. And we saw a need where, as has been discussed already, there have been many different types of principles documents circulating. There have been discussions about what the policy or regulatory approach might be toward AI. But we saw that nevertheless, AI is being built and deployed in government applications and environments. And we anticipate that we will be asked to evaluate these systems to assess them at Congress's request. And to do so, we felt we needed a framework to be able to do that assessment. So our accountability framework is designed as a practitioner's document. And I'll talk about this, I think, a little bit later, but we really, it emerged with an eye toward practical application by auditors, by assessors, by evaluators who would be called in to look at systems and pass some sort of judgment or review on to what extent they were being used responsibly, that they'd been built, taking into account a whole range of factors. We focused our framework on 4 pillars. First one was governance. Second was data. The third was performance. And the fourth is monitoring. And we felt by highlighting each of those areas, we made a good start at covering some of the core areas around AI accountability that evaluators and auditors need to think about. So not only is this useful for auditors and people doing external evaluations of these systems, but we're also hopeful folks who are thinking about how to develop and specify and manage and maintain AI will look at this and think about how others might come in and the sorts of questions that might be asked of the systems that are being built. So our framework is in no way prescriptive. It is not policy. It is not regulation. But it is a roadmap for third parties to be able to ask the right questions about a machine learning or AI or algorithmic system and have that framework with actual questions to ask, with actual audit procedures to follow. We also anchored the framework in the government auditing standards that GAO develops and also in internal control standards. So there's a foundation for the framework that is in language that would be familiar to people who conduct evaluations and audits of different types of systems. The last thing I'll stress is that our framework is publicly available. We issued it publicly earlier this year. If you just search on GAO AI framework, you'll find it. So we're really interested in giving everyone a toehold and being able to start to ask questions about systems even before the full regulatory and policy framework has been fully fleshed out. As we've heard from the other panelists today, there's still a lot of discussion and dialogue happening in the US context of how that will emerge and evolve. But we feel the framework we have now is something that can be used today and was written in a way that's flexible and agnostic to what that policy and regulatory environment will look like in the future. So I look forward to the continued conversation today and happy to be here.
Thank you so much. Thank you to you all for your really insightful comments. I think that's given us a lot to work with and kind of dig into. And I wanted to start with you, Travis. In your comments, you kind of gave this hat tip to the data flows that we heard about earlier. And I know that the Department of Commerce has published its data strategy that's kind of identifying steps on how it will connect data users to mission priorities. I wanted to ask you, how important is it to have a data strategy, and how does that support AI strategies and a vision for AI?
Yeah, no, I think that that's a very good question. And I think that they are, so artificial intelligence, right? Breaking it down, and I really appreciate Jordan going through all the myriad of definitions, right? But breaking it down, it is the analysis of data, right? You don't have artificial intelligence of any meaningful, in any meaningful way, without the data. And a lot of the so-called advances in artificial intelligence are just simply that you have better and more powerful computers running algorithms that we've had for a long time on more and more and more and more data, and actually doing more and more decision making and refining and refining and refining and refining, right? So a lot of the question around how are we advancing, artificial intelligence research and things like that, I don't want to minimize the other aspects of that, right? There are advances that are happening with regards to techniques, with regards to the different ways in which artificial intelligence and machine learning tools are being developed. But a lot of it has to do with, just simply the fact that let me just point out, if we were having this panel in 2016, this panel would be about big data, right? But it's the same conversation. For the most part, it's the same conversation. And so to your point of, how important is it to have a data strategy vis-a-vis the development of artificial intelligence? The US government holds a lot of data, right? I mean, just thinking about it, within the Department of Commerce, we have NOAA, right? All that data from the sensors, all the weather data, we have the census, right? Which does actually have in place lots of tools and techniques by which researchers can access that data. But we have a massive amount of data, and the US government writ large does as well. And the ability to access, to gain insights from, to train algorithms on these data sets is one of the key important ways in which artificial intelligence can advance, right? Can become smarter, can make more correct predictions or descriptions of the world. All that being said, an important factor in the data strategy, and why the data strategy is important, and to the point of this panel, is that it also takes into consideration appropriate use, right, and appropriate limitations on access, and appropriate ensuring that access is equitable. Right, that it isn't just simply the few that gain access to that data, but that there is access to the data by a diverse group, by many different groups. That it is public data and it is available to the public, but that there are those restrictions with regards to concerns about privacy. Thinking about the census and a lot of the work that they have been doing on things like differential privacy, or conversely, ensuring that national security is protected, intellectual property is protected, that data is still being accessed in a way that is appropriate to the context in which it was collected and should be used. So anyhow, I think that was an excellent question.
Thank you. We have a question from Lindsay Hendricks, and I'm going to direct this to you, Sarah. Lindsay essentially asks, facial recognition technology has been the technology that has got the most kind of play, shall we say, in civil society and in kind of policy circles, and is really, there are a lot of privacy and civil rights challenges that are, being raised by the use of facial recognition technology. And so the question is, are there any other kind of AI-enabled technologies that have these risks, and what can be done?
So first, thanks, Lindsay, for the question. I think it's actually a really important question. And I think it actually ties really well into what Travis was just talking about. Sometimes when we talk about advancing AI and improving AI, we forget that AI improvement happens at the sharp end of places we never see. So for example, learning how to deal with complex nonlinear processes over time is a challenge for use of NOAA data and weather data, and being able to then learn from that and port it into things like how to address facial recognition or facial analysis in a kinship verification or an age verification system, where we have to worry about nonlinear processes of aging over time, where we've learned to accommodate some of those tough data challenges by looking at data that's not sensitive, such as weather and climatological data. Learning there can help us to improve and mitigate risks here, where we are concerned about things like uses of biometrics data in our AI applications. So I think one of the, I'm hesitant to say that there is one particular form of technology or one particular area in which AI is used that is, the signal concern. Asking whether or not we have areas where AI really needs to be strengthened because we don't have a very good understanding of the uncertainty around its performance, or we don't have a very good sense of the specification or the under specification of the processes we're trying to model, things like facial recognition, kinship verification. That's how I would start to think of this question. How do we improve AI so that we're not worried about things like uses of biometric identification and facial recognition? I'm not trying to dodge your question, Lindsay, because I think it's a fantastic question, but I think I would just change the way in which we frame that a little bit. There's not going to be one technology. There's not going to be one application that's really of the most egregious concern, because in some cases we're not going to really know what that is until we see it potentially fail, which I think was one of the other questions that came up from another one of the panelists. Who's going to take responsibility in cases of breaches or impact or AI failures? That's an excellent question. I think I'm going to pitch that one to those of you on the lawyer side of the house, because I certainly wouldn't want to wade into that professional territory.
Thanks for that. I'll tee it up and throw it over to Paul. Paul, this question of who should take responsibility, I think it speaks to the kind of wider question that whenever we talk about algorithmic accountability, should it be those who are developing the systems who are responsible? Should it be the operator? Where does responsibility fall? How do you kind of see this question?
Yeah, no, I mean, I think it's a great question, and it's something that's coming up all the time. Because there are so many different people and organizations that are involved in a particular application or deployment of AI. And, I'll give you a lawyerly answer, which is that it depends. It really depends on what we're looking at and where we see the problems to lie. I do think if we're talking about liability and we're talking about enforcement, I think we're going to see out of the FTC some more clarity on what they're looking at. But if we're talking about regulation and who should have the obligations to do different things, I think it really depends on what our objectives are. And that, if we're going to have AI regulation, it's got to be focused on the sectors and the particular outcomes, the uses, really, that we find as a society to be problematic. And so I think in some cases it's going to be a developer. You have to look at the training set that is used, the data training set that's used. You have to look at how the algorithm is developed. But in some cases, it's really more about how the system is then used, because there's a number of these products out there that can be used for good purposes or can be used in a sloppy manner. So I think we have to have enough specificity to be able to capture, different people in the whole chain.
Thanks. And something that you said in your comments was this kind of focus on government algorithms. And so, Stephen, I wanted to ask you, how do the privacy and civil rights concerns from public sector and private sector use of algorithms factor into the evaluation of AI systems?
Sure. Thanks, Hoden. I mean, clearly they're going to be, in some cases, distinct and also overlapping stakeholders when you're talking about public sector and private sector applications of algorithms and AI. Certainly there may be specific laws and regulations that apply in a public sector context that would not otherwise apply to deployments in the private sector. But the stakeholder view, I think, is really important because in all cases, I mean, in the private sector, you're going to have employees as stakeholders, you're going to have customers as stakeholders, you're going to have shareholders as customers. You'll have civil society, in a sense, as a stakeholder too. So that whole map of stakeholders is going to exist no matter what domain we're talking about. And when we convened an expert panel to help us with the framework back in 2019, one of the things that bubbled up to the top from our group of experts was the need to take a really broad look at stakeholders through the entire life cycle of AI development, if we're talking about ways to assure accountability. And I think this comes back to some of the things that were said in the opening remarks too, that I think, Sarah, you might have been talking about this, the degree to which stakeholders actually have transparent access to systems and information as they're being developed, and to what extent those information exchanges are robust and that the input from stakeholders is actually taken on board. So that's something we talk about in our framework, about questions that need to be asked around not just were stakeholders involved, but questions around to what extent were they involved, and to what extent did they have the ability to influence any steps along the entire life cycle of the AI deployment. So that's a very, I think, important thing that rose up that gets a little bit to really in both domains. I mean, we were clearly targeting a public sector domain with what we were developing in the framework, but I could see it being equally applicable to ask those types of questions. The other distinction we made when talking about stakeholders is moving beyond just the technical stakeholders and ensuring that stakeholders are defined as both users of the system and as well as individuals affected by the system when setting up who actually should be a stakeholder, as well as people from legal counsel and civil liberties advocates and civil society groups who may have equities in a particular domain where a system is being deployed. So we stressed again that having that broad view of stakeholders throughout the entire life cycle is pretty important when evaluating one of these systems.
Thank you. We have another question from Austin Gould. It's around competition, and I'm going to hand this over to Jordan. The question is, how do you think we should balance giving US citizens their rights to privacy and preventing AI overreach with the potential competitive disadvantages stemming from our global competitors making widespread use of AI with less restraint?
No, it's a very good question. And, first of all, I'll state this. When it comes to consumer privacy, consumers absolutely deserve to have their privacy protected. And it's for that reason we advocate for a national privacy standard that protects all Americans equally, regardless of where they live in the United States. At the same time, as we're looking at protecting privacy with robust protections, like things like the right to opt out and data deletion and rights to access data that companies have about consumers, we also have to make sure we're balanced to enable innovation to continue. And there are concerns about things like global opt-outs that could effectively be a global opt-in for getting access to data for companies. And why is this important? Data is key in many ways to solving many of the societal problems that we have. And cutting off those flows of data would be detrimental in many ways. For example, companies are using consumer data to protect them using artificial intelligence from fraudulent bank charges, for example. When we look at the issue of bias, we actually partnered up with Deloitte to do a report on trustworthy AI, and we polled 250 individuals who are decision makers or AI researchers at companies across the country. And while 68% warned that bias in decision making could lead to an erosion of trust in AI, they also believed, and it was 76% believed, that AI could be used to remove subjectivity and bias from things like scheduling and promotions. So it's all about using data in the right way, and we want to make sure that we don't outright cut out data flows entirely when we're dealing with consumer privacy. So those are areas where we think we should have balance. And really, to be frank, if you want to have a balanced privacy regime in the United States, it's going to be difficult for the United States to compete in technology with 50 state regulators and potentially a 51st with the FTC when you're dealing with countries that have unified privacy frameworks.
Thank you. And thanks for bringing up kind of opt-in and notice and choice. Sarah, one of the kind of things that we hear in these kind of debates is people kind of coming against this consumer-centric approach to privacy because they argue, even if you're doing it right, it's too difficult when it comes to AI systems for consumers to know, how it's being used to make decisions about them. And so some people are against notice and choice. What's your take on that?
Well, in terms of notice and choice, I think a lot of us find it unsatisfying all around, right? Whether or not you're on the perspective of the business side or you're on the consumer side. Giving people adequate notice can be difficult. Are they actually paying attention? What did they get from it? How much did they understand? Thinking about, for example, NIST in terms of the explainability and interpretability of AI is such a great report to highlight exactly how difficult it can be to give people adequate notice that they can take on board that is interpretable for them. And then in terms of choice, well, choice at what point? As all of us know, you probably logged onto your computer this morning and had to click on 4 or 5 cookie banners to get through to just the weather report. And that question is that really a choice? And asking whether or not that's something that is going to help us as we sort of deal with an AI-enabled world, I think it's time to start thinking a little bit more creatively about how it is that we notify customers of what data is being used about them and how we share that and how many different organizations and types of organizations we share that. At FPF, we're working a lot with researchers and academics to make sure that they can access data, whether or not from administrative agencies and administrative data or corporate data, in order to make sure that machine learning researchers have what they need to train better algorithms. Well, how do we meaningfully notify someone of very long-range concerns about secondary uses of their data? In fact, the NIH is taking in comments on their application for that right now in terms of secondary uses of data and biospecimens. We're all grappling with that question because we all, I think, consider that to be not particularly the most satisfying way to deal with this. But I think the most interesting question about the notice is, well, what's the extent of notice? I mean, one of the other questions that we have come in here is, well, is an algorithm that's been trained on your personal data something that is your personal data? And I think, looking at that question there that came from, Mauricio Hernandez, I think that that's an excellent question and something that we need to grapple with in terms of how effectively we notify people about the training of algorithms, say in the precision medicine space, where the connection between you and your personalized healthcare profile and the ultimate algorithm that comes out to, say, deal with a rare disease is quite coupled. But that may not be pertinent in all verticals. Back to sort of industry-specific type of regulations that we're going to need to address. So maybe we can come back to some of the initial comments that I made at the beginning, which is that we can talk about notice and choice as something that helps us to create somewhat meaningful, but perhaps room for improvement, privacy protection. But it probably needs to be pertinent to the application, to the sector, even the user, reflecting on that NIST interpretability report. How we take in that data and our mental model of how we understand that is going to say something about how we perceive whether or not we had a choice in terms of that data access and that data use.
Thanks. Travis, I'd like your thoughts on this. I see you smiling. And, you know, the six of us on here would have different privacy kind of preferences. So what's your take on this? You're on mute.
Apologize. I think that literature has just generally shown that notice and choice is, to Sarah's point, insufficient, right? It's not really enough. And one of the things that has come out with, particularly with artificial intelligence, one of the uses and what makes AI awesome is irrational conclusions, right? Where you put in data and you have, I click on an advertisement for TV, and all of a sudden everything everywhere is TVs all the time, right? There's a rational link between the TV clicking that ad and the other things that are going on, the advertisements that I get, right? Artificial intelligence allows me to say, to go to the store and buy some fish, and then all of a sudden have TV ads everywhere, right? Where it allows for irrational connection, such that things like some of the transparency around data doesn't necessarily link in terms of how a rational person would think about things into what the actual ultimate results are. And the thing is we have dealt with these kinds of concerns and conversations before in terms of notice and choice, or rather, I guess the other thing too is in a lot of ways, artificial intelligence is not something that people can actually opt into often, right? Like the algorithms that are being used to decide things about them have been trained on other people's data, or their data is being used to train the data, but they're not actually the targets of those algorithms, right? So, but we have some models, such as the Federal Fair Credit Reporting Act, where there is some degree of understandability of correction, of being able to gain some insight and have some ability to correct and understand what seems like irrational, data points, and how that ultimately leans in onto some of these things. And this goes into a little bit of the underlying quandary, which is like, how does privacy, which is like the flows of personal data, and what the context of the flows of those personal data is, whether or not that's proper, right? Definitely comes into play. Jordan, mentioned earlier about different definitions of privacy, and I think that the contextual integrity one is a very compelling one, because you can talk about how how data does not necessarily need to be public or private, or used or not used. It's a question is whether or not those uses are appropriate to the contexts that they were collected in, appropriate to in terms of respecting the dignity of the individuals from whom it was collected, and also upon whom these algorithms are then being targeted, and that in terms of thinking about it of the data flows that way, I think it's somewhat helpful. And then just one last thing, since I'm talking, I love the question about what the scariest thing about the scariest technology, and I know that we're way past that, but I do want to jump in there really quick and just simply say that I think that what is scary about some of the artificial intelligence applications is the big one that I would say is just simply where it's treated as an objective measure of social constructs, right? Where the thing that is supposed to be measuring is actually a squishy social construct, and the algorithm itself is being treated as an objective measure of that. And in those circumstances, in those situations, particularly where the outcome of the decision has very strong, hard, real-life consequences, I think that those are the worst. And I think that's one of the reasons why facial recognition has come up as one of those areas, because identity, even though as much as we think of it as an objective construct, it is in fact something, particularly when you're adding on what your identity means in different contexts, is something that's very socially constructed.
Thanks. And just to, I guess, to somewhat balance the kind of conversation, because privacy and AI are kind of often framed as being inherently in tension, but there are ways in which AI systems can improve privacy, whether that be, you know, automating processes so that you know, humans don't have to see your personal data. If I'm, you know, working at a place and I'm giving a vaccination card and it's being automatically processed, a human doesn't have to see it. You know, Jordan, do you think that there are kind of other examples in which AI can enhance privacy?
Well, yeah, I mean, I think that AI can enhance privacy. I think it, as I mentioned earlier, I think it has the ability to enhance security in many ways of data. I think that AI can be used in new ways as well, even to help with anonymizing data and working with data sets in ways that enhance privacy as well. So, you know, I'm a firm believer that technology can also be the solution to many of the issues that we face. You know, it's one of the reasons why, you know, going back through a report we talked about, you know, 83% of those making decisions at companies and doing research on AI companies truly believe that government investment in research and development can lead to solutions to develop trustworthy AI. And given that, I think there has to be a right balance of regulation. There also has to be a right balance of R&D and development and privacy enhancing technologies. We've seen a lot of actual legislation out there as well that seeks to do this. For example, Senator Cortez Masto has a bill that has that tasks the government with developing privacy enhancing technologies as well. It's a good bill. And so, you know, also thinking outside the box is important to the debate, in addition to just some of the regulatory issues too.
Thanks. And thinking about what can be done, which is the hard questions. Paul, you mentioned that, you know, what the EU is doing might not necessarily work in the US context. Can you dig a little bit deeper into what's kind of unique about the US context and what will work from the EU and what won't work?
Yeah, no, I'm happy to do that. I mean, I think there's the first and foremost, you know, the EU proposal is the first comprehensive AI regulatory proposal that we've seen in the world. And so it is jump-started a debate into what exactly would regulation look like and where do we actually need to scale back. So I think that's very positive. It's received wide praise, and I concur with the risk-based format that has been put out there, where there are more compliance requirements and reporting requirements and assessment requirements for those systems that are considered to be of higher risk. That means that under the European rubric, they have a more direct potential impact on fundamental rights. And some of the things that Travis was just talking about, you know, beyond facial recognition, these social constructs, and also situations where a benefit may be conferred as a result of a decision that is generated through an AI. So I think all of that is very positive. What I think, though, is that it's a bit too expansive, and it doesn't really focus in on where we have potential problems. And because of this, it's going to be really difficult for companies to comply with it. And I think it's also going to be very hard for government authorities to be able to monitor and ensure that compliance is adequate. So I think that we have to focus much more in on, you know, what the problem set is and what we're hoping to achieve. We also, as a starting point, need to be very clear in our definitions. There are some definitions in the European Act that are very broad. Even the definition of artificial intelligence can mean many different things. And I think Jordan read that earlier today. So, you know, I think that it is a good starting point for a discussion, but it's just not something that will work here. And we need, if we're going to look at legislation, we need to make sure that we have focused legislation and that we bring together all the different constituencies who would have relevant input here. So we need to get engineers together with policymakers, together with lawyers and so forth, to try to figure out what actually is going to make sense and what is going to address the problem. I'd say in the EU Act also, there are some assumptions that are built in that I think and hope will be smoothed over in the next couple of years as they debate this. One of them is that it requires AI systems to use data sets that are relevant, representative, and free of errors and complete, which is a virtually impossible standard for anybody to actually meet. So, I think there's a lot that's interesting there. It's just not really the right approach for our environment here in the United States. And I think that the last point, and then we can move on to other questions, but when we're looking at a comprehensive piece of privacy legislation in the United States, which many people think is absolutely critical, something at the federal level rather than 50 different versions at the state level, privacy is something that's very different than artificial intelligence, even though there's overlap. With respect to privacy, we're looking at the collection, we're looking at the use of information. Artificial intelligence is really about the data and the algorithms and then the applications or deployments of the artificial intelligence. So it's something that can't be regulated in quite the same way as privacy. And so I think we need something that's much more tailored to the particular problem set that we're trying to address here.
Thank you. One of the things that I'm kind of hearing is this move towards these kind of concrete things and moving away from these like high level principles that are somewhat vague. And Stephen, many of the frameworks for privacy preserving and ethical AI do include these high level kind of principles. But just how do principles differ from actually auditing AI systems for the data they use and the way that they perform?
Yeah, it's a great question, Hoden. And that's obviously something we had in mind when we were developing our framework. Principles can be binding, they can be non-binding, opt-in, opt-out. Sometimes they can really, unify a group and drive adherence. Sometimes they can be used as a little bit of smoke and mirrors. So, having principles is important for the dialogue to continue, but the principles don't really help auditors. Auditors deal in the world of needing concrete criteria and questions to ask, and procedures to follow in order to evaluate a system. And sort of high-level principles come up a little bit short for auditors in that way. So, we really focused on a couple of things in terms of putting a lot of emphasis on what across the life cycle, again, looking at, say, the design of a system, looking at its development, the deployment, and then the operation and monitoring of that system moving forward. And also thinking about some core pillars to dig into as an evaluator. So this is, as has been mentioned already, the importance of data, which is the lifeblood of many of these machine learning systems, but asking questions and assessing to what extent, as has been mentioned already, one set of data may have been used to train a system, but the system may be pointed to another set of data during its operation, or a particular algorithm or application might drift into other domains and be used with different populations or with slightly different purposes. Something else that was really important for us to define were audit procedures and questions around a system's performance. And I think that's an area especially where some of the principles don't get into as much. But did the system, first of all, were concrete metrics for performance expectations set while the system was being designed and developed? And were those well understood? And then is there a mechanism in place once the system is deployed to actually monitor those performance metrics and take actions as required if there are deviations from those expected performance levels? So the whole performance dimension is one that we have a lot of questions and procedures around that I think puts the auditing or examination of these systems a little bit more in the real world, and gives evaluators a set of tools to look into them. Equally important is this whole principle of monitoring and seeing when an AI system may actually no longer be relevant to the problem it was originally set to try to solve or help with. The real world may have drifted far enough away from what the model was developed to do initially that it's no longer actually performing the way it should. So what are the provisions for sunsetting a particular implementation of a system? Questions like that we think are also really, really important, that get much more to where the rubber meets the road on the deployment and use of a system, as opposed to more high-level principles.
Thank you. Kind of jumping off this idea of evaluation, Travis, what new privacy concerns relating to the interdependence between AI, IoT, and 5G have emerged, and maybe even AR and VR?
Sure. Well, I mean, it's a little bit of, the blind wise man and the elephant, right? Of, different aspects of a similar issue and similar problem. With IoT, you see a mass explosion in connected devices in new contexts, right? Where connectivity wasn't there before. With quote unquote big data, you have vast increases in the ability to create and manage data sets. With artificial intelligence, you have new and increased tools and techniques to decide things and to move forward and make analysis of this data. And I think at its core, at its core, the issue is one of disrupted social context, right? Where at its core, what you're seeing is the move from telephone booths to cell phones, right? Where in telephone booths or sitting at home on your phone, you'd talk about anything and you'd be quote unquote private. Now with cell phones, people continue to talk about anything on the subway or whatever, but we all ignore it, right? We all socially, politely ignore what's being talked about. And there's kind of like that redeveloped social norm. And so with each of these, you see a potential disruption in the way things worked. And that goes into the questions around privacy, but it also goes into some of these larger questions around equity and civil rights that we're discussing. And to a certain extent, like, that's not a bad thing, right? Disruption of social norms can lead to better social norms, more equitable social norms, more privacy, like we were discussing, right? However, it also can lead to disruptions that are uncomfortable for people, that reify social inequalities or create situations where people's data used to be private and now is easily exposed, and in ways that they did not expect or did not want, bringing these technologies into their homes or having decisions being made about them. And so I think that that's kind of the connective tissue throughout it all, right? Is that that these technologies, most of which are not new, right, in any real sense, right? IoT, we've had connected devices. Artificial intelligence, we've had for a long time algorithmic decision making, and we've had for a long time algorithmic decision making that can learn over time. The question is what is happening now, such that there is something of a convergence where we have more data being collected in more social contexts that is able to be used in ways that were unforeseeable before. And so with each of those, and this is a plug for the ultimately at the end of the day, the contextual approach that looks to the history of laws that have regulated industries and areas such as civil rights prior. That what we need to do is we need to look at how these technologies have changed things, how they have not, and whether or not these sectoral or focused laws need to be updated, or simply the enforcement thereof need to be updated. And that can be informed by broader principles, or it can be formed by kind of a regulatory framework. But I I do think that there's a significant merit to the backwards looking approach.
Thanks. I would challenge whether we all really ignore people talking on trains and things, but that's a conversation for a different day.
We pretend to, at least. We pretend to, right?
We do. We only have a couple of minutes left, and there's one clarifying question, I think that's for you, Paul. When you mention making a developer responsible for an AI system impact, could you provide a more detailed picture of how that could be implemented? You're on mute.
There are different people in the chain of development of an AI that have different levels of responsibility potentially. I mean, on the question of liability, if we're not talking about, you have the responsibility to do an impact assessment, but you could potentially be liable for something that goes wrong. I actually think, we already have the laws and the framework in place to deal with those sorts of things. We have the common law, we have negligence standards, we have FTC has some authority to go after individuals and organizations for different things. And I expect in the autonomous vehicle context that the theories of liability are going to be built out a bit more. So, it's hard to really point to a specific example. I would say that I think this is all going to work out. And that, what we should really be doing if we're looking at a regulatory framework is focusing on what sort of compliance measures do we want companies and individuals to adhere to, and potentially what sort of monitoring may be required in special situations. So that's my non-answer to that very good question. Thank you.
Thank you very much. I think we're coming up on the end of this panel. Perhaps a final word from you all in the last 2 minutes or so, the kind of takeaway message that you want everyone watching here to leave with. Sarah, I'll start with you.
Sure. I'll use my 2 minutes to echo a couple things that I think were said that were brilliant, that may need a little bit more elevation. Jordan, when you say we need more research into the efficacy of particular privacy enhancing technologies, absolutely. Not only which ones work, but with which data and when should they be employed, depending on the data type and the data size. Stephen, absolutely, right? Some of that actionable guidance on which PETs we should use in order to accomplish our algorithmic goals should be incorporated into things such as auditing guidance, because then we would know what to necessarily look for. And I absolutely love that last point that you slid in there about decommissioning some of our systems. What happens when we sunset things? In particular, what happens to people's personal data when a startup closes or an established company decommissions a product and the data that they have gathered together as an open machine learning data set is now set adrift? How do we make sure that that personal data is continued to be protected into the future, even without that company? So thank you so much for having me. And I loved those 2 points. Those were great.
Thank you. About 1 minute left. So Stephen?
Well, I just think it helps if everybody thinks like an auditor sometimes and thinks about the types of questions that can reasonably be asked about systems when they're actually deployed. And I think that would get us a long way toward getting some level of assurance that the systems are doing what they should, realizing their potential while maintaining protections that we've come to expect from them.
Travis?
Just really quick, I think that the framing of this panel is a very important one, looking at artificial intelligence, privacy, and civil rights. And I think that's an area that touches on a lot of key priority policy areas for the administration, and the administration is focused on that and will continue to focus on that.
Thanks. Jordan?
I think the point is to be made that all technology comes with benefits and all comes with risk. And technology can be used to solve many of the concerns we have, but at the same time, regulation that's balanced that also can provide protection to individual liberties as well. So we think a national data privacy standard, for example, is a way to get there.
Thanks. And last, Paul.
Thank you. I think we need to be thinking creatively about regulation. There's been so much work done behind the scenes. We have excellent frameworks out there to guide companies in developing and deploying AI, and I think we need to focus really on whether there are some measures that should be taken at the congressional level.
Thank you all so much. Thank you.
Thank you.
And now I welcome to the studio Senator Marsha Blackburn, who is the ranking member of the Subcommittee on Consumer Protection, Product Safety, and Data Security. In July, Senator Blackburn introduced federal data privacy legislation called the Safe Data Act. So thank you very much for being here, Senator, to discuss that with us today. The floor is yours. Sorry, I was a little too excited. Now, Senator Marsha Blackburn, who is the ranking member of the Subcommittee on Consumer Protection, Product Safety, and Data Security, is here. In July, Senator Blackburn introduced federal data privacy legislation called the Safe Data Act. So thank you very much for being here, Senator.
Oh, thank you. I'm delighted to join you. Thank you so much.
Thank you. I hand the floor to you.
Thank you, ma'am. I appreciate that. Let's talk a little bit about the big tech explosion that we have really seen across the country. And I think over the last 18 months, each and every one of us have watched our relationship with digital platforms grow and grow and grow every single month. More people than ever really depend on these platforms for services and for a lot of their functional and transactional life, which means in turn that big tech companies have unprecedented access to a constant stream of your data. It was difficult pre-pandemic to avoid using some of these platforms. They're so convenient, but it's almost impossible now. And for those who are still working from home, it even becomes more problematic. Work from home policies mandated online activity, which in turn created a situation in which every adult had less control over what I call their virtual you, which is you and your presence online. I've been especially interested in how this has affected our school-age children and the impact that it is having on their emotional and mental health. We already know from recent reporting that's been done by the Wall Street Journal that these platforms have a truly toxic effect on mental health. And we're seeing this primarily with children and teens, forcing kids onto digital platforms for hours every day has almost assuredly had an additional negative impact on privacy and personal safety. And I think as we move forward, we'll be able to do a better job of quantifying exactly what that effect is. More broadly, when we think about creating new privacy laws, we need to consider all users and pay very close attention to how big tech approaches their relationships with those users. We know that in general, companies like Facebook, Google, Twitter are successful because their back-end advertising capabilities are successful. The tracking features that they use have become increasingly effective and complex, which means that it's even harder these days for consumers to understand how platforms are actually collecting their information, how they hold it, how they data mine it, and then, of course, where does this information end up? In what form? With third parties. So people are wanting answers on this. Clarity, transparency are an issue, and over the past few years, we've seen multiple states decide they were going to take matters into their own hands and that they were going to do their own privacy laws. And the FTC has suggested that the FTC, would begin their own process to look at some privacy rules. And while we do appreciate the visibility that these policies have brought about, well, the policies also having states, having the FTC, this leads you to a patchwork system. You've got different legal structures. It causes confusion for everybody, not just developers, but also for those that have online platforms and additionally for users. While I was still serving in the House, I introduced the Browser Act, which was one of the first bipartisan privacy bills in Congress. This year, Senator Wicker and I also introduced the Safe Data Act, which would set up the framework for a federal privacy regime, which would exercise federal preemption. I absolutely support getting some form of consumer privacy legislation over the finish line, but I want to be clear about what standards we believe should guide any piece of legislation that Congress considers. Both of my bills and others like them offer a set of guide rails rather than a strict list of do's and don'ts or mandates. We believe that this approach will allow the innovators to innovate and drive the free market in the right direction. It will also leave room for the FTC and Congress to conduct sufficient oversight that is responsive and able to keep up with the pace of development in the online space. Today, we had a privacy hearing at Commerce Committee. It's good to get people in front of us who have worked in this space, former FTC commissioners and to others who can bring their views to bear as we consider how to move forward with privacy. The bottom line is this: big tech companies are entangled in our daily lives. It's hard to untangle ourselves from these. They are involved in the lives of our children, as children have been forced to spend more time in the virtual space, and they have absolutely no incentive to loosen their grip on our attention by making things easier to understand. Therefore, we have no incentive to assume they're acting with the best interest of the consumer, the online consumer, in mind. And that's what we're keeping in mind as we move forward to address this issue. Thank you so much for letting me join you today.
Thank you so much. I have a couple of minutes of your time left, so I'd like to ask you one or two questions.
Sure.
The first is your legislation, the Safe Data Act that you mentioned, would have large data holders conduct ongoing privacy impact assessments, which is similar to the external risk auditing requirements in the European Commission's proposed Digital Services Act. Do you see an opportunity for harmonization on these types of requirements? And how might there be more kind of transatlantic cooperation?
Well, you know, one of the things that we know is that our EU friends are looking at what they have there with the GDPR and are saying, what are the changes that we need to make? This has provided us an opportunity to work with them. It feels like the EU and the US have different views on how you balance privacy and innovation. The GDPR, for example, is an approach that is too restrictive and burdensome to encourage the type of innovation that we've tried to develop here in the US. I think that whether you're talking to those in the UK or you're talking to members of the EU, they will tell you that they think it's time that they need to pull back on these restrictions. And if we want to maintain US leadership against companies like China, we've got to be careful about how we go find this the balance. I do think that Digital Markets Act is an interesting idea and shows how there is a global concern about the practices of big tech platforms. I think that the more people look at more of their functional and transactional life being online, the more brick and mortar companies continue to innovate in that virtual space and move portions of the work that they're doing there, the more there's transatlantic cooperation that you are going to see people say, we need to revisit this. So you're seeing conversations here in Congress about that. You're also seeing conversations about privacy, about Section 230, about antitrust. So I think that there's good momentum and there is space for having these conversations on a more global scale.
Thank you. Another one of the questions I had for you was, one of the goals of any data privacy legislation is to improve security. And one of the ways to do that is by creating better systems for online identification and authentication, so consumers can securely authenticate to online services. Do you see a role for the federal government to offer solutions like EIDs so that consumers can better manage their legal identity online?
Well, I think first of all, we need to look at what the private sector can do and say, okay, here is a space where the private sector needs to say these are best practices. And they can step in and they can provide creative solutions for consumers. And they ought to be doing that every single day. It's frustrating that many times big tech companies have chosen not to step up and do this. I would be concerned if the federal government had access to all of this consumer data. Why do they need it? What are they going to do with that? As we saw with take the IRS data leak that occurred, for example, federal agencies have a very, very long way to go before we can trust them to safeguard your data. And it doesn't matter if it's financial, if it is healthcare data, and look at the the vaccine passport issues that have propped up with people having real concerns about what is happening with their data. Now, I do think that the federal government can play a role in educating consumers and businesses about steps that they should be taking to protect their data and putting a focus on cyber hygiene. And that would be wonderful to see the FTC step up and take some of those steps on an educational basis.
Thank you so much. Thank you for your keynote and thank you for answering my questions.
It's good to be with you. Thank you so much for letting me join you today. Bye-bye.
Bye. To all of you at home and who are joining us, up next is a 15-minute coffee break. I encourage attendees to use the networking function or to visit the expo area in this time. And we'll start up again here on the main stage at 3 o'clock with a keynote address from Senator Amy Klobuchar.